A Section 8 notice under the Housing Act 1988 is a legal process that landlords in England and Wales can use to regain possession of their property when a tenant has breached the terms of their tenancy agreement. Here's a detailed explanation of what a Section 8 notice is and how it works. What is a Section 8 notice? A Section 8 notice is a formal notification from the landlord to the tenant that the landlord intends to seek possession of the property based on one or more of the statutory grounds for possession listed in Schedule 2 of the Housing Act 1988. It is typically used when a tenant has breached specific terms of the tenancy agreement. Grounds for issuing a Section 8 notice. The grounds for possession are divided into two categories: mandatory and discretionary. Mandatory grounds. For example, grounds 1 to 8. If proven, the court must grant possession. Examples of this include Ground 8, rent arrears of at least 2 months or 8 weeks at the date of the service of the notice and at the date of the court hearing. Ground 7, the tenancy has devolved under the death of the original tenant and the landlord wants to regain possession. Discretionary grounds are grounds 9 to 17. The court has discretion to grant possession based on the circumstances. Examples include Ground 10, some rent arrears are present, but they do not meet the threshold for Ground 8. Ground 11, the tenant has persistently delayed paying rent. Ground 14, the tenant or someone living with them has caused nuisance or annoyance to neighbours. Let's look at the process of serving a Section 8 notice. Number 1, identify the grounds. Determine the specific grounds for seeking possession and ensure they are valid. Number 2, complete the notice. Use the prescribed form for a Section 8 notice. This form must be filled out accurately, specifying the grounds for possession and providing details of the breach. Number 3, serve the notice. Serve the notice to the tenant in accordance with the legal requirements. It can be delivered in person, posted, or sometimes left at the property. Number 4, the notice period. The notice period varies depending on the grounds used. For example, grounds 8, 10 and 11, rent arrears, have at least 14 days notice. Ground 14, nuisance or annoyance. No notice period is required before court proceedings can begin. Ground 2, property is subject to a mortgage, at least 2 months' notice. Number 5, court proceedings. If the tenant does not leave the property by the end of the notice period, the landlord can apply to the court for a possession order. A court hearing will be scheduled where both the landlord and the tenant can present their cases. Implications and considerations. Court decision. For mandatory grounds, if the landlord proves the case, the court must grant a possession order. For discretionary grounds, the court will consider the circumstances and may grant possession if it deems it reasonable. Rent arrears. Using Ground 8 for rent arrears requires the arrears to be 2 months or more, both at the time of serving the notice and at the court hearing. The tenant's response. Tenants can defend against a Section 8 notice by disputing the grounds, claiming retaliatory eviction, or showing they have resolved the issue. For example, paying off the arrears. The costs. Court proceedings can be time-consuming and costly. Landlords should be prepared for potential legal fees and the possibility of a lengthy process. Let's look at the alternative solutions. Before resorting to a Section 8 notice, landlords might consider resolving disputes through mediation or reaching an agreement with the tenant. A Section 8 notice is a powerful tool for landlords to regain possession of their property when a tenant breaches the tenancy agreement. It requires careful adherence to legal procedures and a clear understanding of the grounds for possession. Failure to follow the correct process can result in delays or dismissal of the possession claim. Landlords should ensure they complete the notice accurately, serve it properly, and prepare for possible court proceedings if the tenant does not vacate the property voluntarily.